Lawyers have read it. What was your oh shit moment in court? Story 1. Not an oh shit bad, but an oh shit. I can't believe she said that. It was my first jury trial, and the charges were pretty serious. I was cross-examining the alleged victim, and in response to my question, she said, "Oh yeah, I lie all the time." Needless to say, I won that trial. Story 2. A story from a friend of mine. He was defending a guy in court, though I don't remember what he was charged with. The main witness for the prosecution was on the stand and was asked if she could identify the defendant. She was scanning the courtroom and seemed confused. My friend was already silently celebrating because if she couldn't identify him, he could probably get all charges dropped. As he was mentally adding this case to the win file, he happened to glance over at his client, who had just helpfully raised his hand to make it easier for her to identify him. Even the judge facepalmed at that one. Story 3. I was sitting in the public gallery at a bail hearing for a man accused of heinous crimes against a very young female relative. The judge began laying out the conditions of bail, and one of them was to surrender his passport. The man turned to his attorney and said, loudly, something along the lines of, "But you said I could fly back to my home country." The judge stopped mid-sentence and immediately revoked the man's bail. Story 4. A lawyer I used to know was in court for a work injury case. The judge asked his client, "What exactly is the nature of your injury?" The client replied, "I can't raise my arm this high anymore," while raising her arm to demonstrate just how high she supposedly couldn't raise it. Story 5. I was prosecuting a contempt action in family court, something that almost never works, and everyone in the room could tell I was winning. The other side was unprepared, out of arrogance, and I was basically ripping this guy to shreds on cross-examination, which his lawyer didn't even think would happen, as he expected the case to be dismissed. At the end of the trial, the judge ruled in my favor and stated that she found the defendant's testimony untrustworthy. I was shocked to win a contempt trial to begin with, but then this exchange happened. Defendant's attorney: "Your Honor, now that you've found my client's testimony untrustworthy, I am requesting a continuance to prepare additional witnesses." This concept is shocking in and of itself, because the idea of bringing more witnesses after resting your case is laughable. Judge: "You had your shot and you missed, counsel." Defendant's attorney: "Your Honor, there was no way I could have anticipated that you'd find my client's testimony untrustworthy, and as such, I didn't have the opportunity to prepare other witnesses in support of his position." Judge: "That may be an argument for your carrier, counsel, but it holds no water with me. See you this afternoon for sentencing." For those who didn't pick up on it, the judge basically told the lawyer on the record, in front of his client, that she expects him to get sued for malpractice because he screwed up so badly. That was mind-blowing on multiple levels. Story 6. I was the defendant, representing a non-profit that I volunteered for. The plaintiff was a 60-something grandma who was looking for a retirement settlement after falling out of her jacked-up pickup truck in our parking lot. The premise of her case was that our parking lot was in bad shape, and that she fell into a pothole and broke her leg, which resulted in her having to take Coumadin and diminished her enjoyment of salads at the Friday night fish fry. Yes, really? It was going along fine until my lawyer presented a photo of the pothole, taken the day of the incident, filled to the brim with water after a recent rain. He asked the lady if she had gotten her foot wet, to which she replied that she couldn't recall. He talked a little more about how, perhaps, if her foot wasn't wet, it might have been because she fell out of the truck and didn't actually fall into the pothole. He asked again if her foot was wet, and this time she affirmed that yes, her foot was wet. The oh shit moment came when he went back to his desk, flipped through her deposition, and read the part where she was extremely adamant that her foot wasn't wet. Then he did some fancy legal stuff. The case was thrown out, and I went back to work. Story 7. I was the dumbass who almost screwed myself. I had 2 charges in 2 different courts. I accepted the first plea, which almost always carries probation, but my plea didn't include that condition. When it came time to accept the second plea, the prosecutor didn't include probation because she assumed my first charge already put me on probation. She even said as much to the judge, and me, being a big dummy, almost corrected her. My lawyer grabbed my shoulder and, I kid you not, told me to shut the fuck up. She doesn't know. Story 8. I was just interning in court during law school, but I'm a lawyer now. There was a fight in a club where someone had broken someone else's jaw, and the defendant had 6 friends with him who insisted he had been wrongly identified because he never had a beard, and the victim claimed the perpetrator had a beard. They all used a very specific phrasing, something along the lines of, "My friend doesn't have facial hair because he is a professional in the food industry, and it would go against the regulations." After 3 of the witnesses repeated the exact same phrasing, the judge stopped one of them to ask if he knew what a couple of the terms in that line meant. The witness couldn't explain it. The defense lawyer got busted for instructing the witnesses. To make matters worse, she had also convinced the defendant to reject a plea deal that would have exchanged prison time for a fine and community service. Story 9. Not a lawyer, but I had a big oh shit moment. I was in court for driving while suspended, in a county and in front of a judge both notorious for jailing people for that offense. My license wasn't supposed to be suspended. A pencil pusher forgot to press a button or something, so it never got reinstated after the suspension period ended. I had proof of this, but I was still really nervous. The guy who went up to the judge before me walked to the table where we were supposed to stand, sat down, and put his feet up on the table. The judge asked him what he was doing, and he gave a flippant answer, basically telling the judge to get fucked. This seriously pissed the judge off. The judge went off on the guy, and the guy kept giving it right back, pissing him off more and more. The judge ended up jailing him for contempt and had the bailiff cuff him and put him in a chair off to the side to wait for the marshals to transport him to jail. Then my name gets called. The judge is looking at me like I'm fresh meat, and he's a great white shark. I'm already thinking to myself, okay, if this judge puts you in jail, run over and beat the shit out of the guy who pissed him off so badly. He's the reason you're going to jail. The judge looks down at his paperwork, back at me, and says, "You're Mr. my last name?" I said, "Yes, sir." He said, "Yeah, we were talking about you earlier. I'm going to void your arrest and dismiss this case. Your license was supposed to be valid, and you shouldn't be here." I let out a huge sigh. The judge asked me if I was okay, and I said I had been a bit worried, especially after seeing the guy who went before me. The judge said, "Don't worry about him. He won't be seeing anything that isn't behind bars for about 90 days, and laughed. Story 10. I was involved in a pretty messy custody case. The other party was a disaster and had kept the child from my client for several weeks. The opposing party, OP, was playing a lot of stupid games and kept requesting continuances. I requested a drug test, which the judge ordered. However, the OP didn't follow through with it. To clarify, he did show up but stood in front of the toilet for literally 2 hours and claimed he couldn't pee. I was representing the plaintiff, so the burden of proof was on me. I called multiple witnesses who testified about the defendant's drug use. Then, opposing counsel decided to call their client for direct examination and asked, "You don't use heroin and crack, right?" For the non-lawyers, that's a very stupid question for several reasons, especially considering his client didn't complete the drug test. I fully expected the defendant to lie and say he was clean. However, after the question was asked, there was a really long pause, and the defendant said, "Yes, I do both of those drugs." My head almost exploded. I didn't ask any questions on cross-examination because I didn't want to muddy the waters. I won, and the child is doing great. Story 11. The best oh shit moments are when your opposing counsel or opposing client says or does something that wins the case for you. True, in civil cases, you usually know what will happen ahead of time. But in my state, discovery in smaller civil cases is more limited, and clients don't always want to spend $30,000 when we can get the same result for $10,000. In an adverse possession case, the witness only needed to say, "I used that area as my backyard," and I fully expected him to say this. It would harm my case, but I knew I could work around it. When asked about his use of the area, he said, "No, I never really went back there, didn't use it at all." That single statement lost the case for the other side, and I could barely keep a straight face. It was completely opposite of what the witness had told opposing counsel off the record. Apparently, the under penalty of perjury part made him change his story. I had another case about a guy losing multi-unit dwelling insurance because his place was a fire hazard. I asked him if his personal insurer knew about the fire hazard. He replied, "Yeah, and the jerks canceled my policy." I also love it when I have a difficult party on the other side, and the judge rips them a new one. I had a convoluted case with a lot of parties about essentially nothing. The plaintiff was heinous. While the 6 or 7 attorneys were working out calendars with the judge, the plaintiff started yelling at her attorney from across the courtroom because she didn't like that he had conceded some minor non-issue. The judge told her to sit down and shut up. I was sad that the case settled because she would have been amazing on the stand. Story 12. New judge with a chip on his shoulder. The plaintiff called me to request an adjournment on a summary judgment motion I had filed. They wanted more time to submit opposition. I didn't have a problem with this, but the court refused to accept the adjournment request over the phone and said we had to appear in court the next day. So, I went, but the plaintiff didn't show up. When our case was called, I requested the adjournment, and the judge exploded on me, demanded to know why, insisted he didn't grant adjournments, and just yelled for no reason in front of a courtroom full of attorneys. I explained that it was the plaintiff's request and they weren't there because they wanted more time, but he didn't want to hear it. He just said, "Request denied. Call the plaintiff and tell them to get here by second call." So, my oh shit moment. I just won my case because the judge decided to be a jerk. I called the plaintiff to let them know what happened, and they panicked. They were about to lose their case. The judge had to grant my motion. It was unopposed. There was no way they could get an attorney to court in time. The case was called again, and once again, I was the only attorney present. I went up to the defendant's table with the biggest shit-eating grin on my face and said, "Your Honor, I'm here on behalf of the defendants with an unopposed summary judgment motion." Everyone who had watched me get yelled at earlier suddenly realized what was happening, that I was getting yelled at for trying to be helpful, and that the judge's outburst effectively meant I won. The judge had no choice but to soften, rehear my request for an adjournment, and grant it. Follow up. The plaintiff's client passed away, and the motion was never opposed or heard. When they tried to reactivate the case with an administrator, I reminded them that my motion was the first thing to be heard once the case restarted. After reviewing it and realizing they had no chance of beating it, they discontinued against my client without ever arguing the motion. Story 13. I was a baby lawyer in my first year, representing the 19-year-old child of some wealthy people in San Mateo County, CA. My client had gone on a bit of a shoplifting spree, and we were cleaning up all her cases with a global plea, meaning we handled them all at once. Being new, I filled out the plea form incorrectly, swapping the counts she was charged with for the counts she was pleading to. It's an easy mistake to make. Every court has its own unique form, and I was unfamiliar with San Mateo's. The judge calls my case, starts reading off the plea form, notices the mistake, and then starts screaming at the top of his lungs. "Counsel, what is this? What is this? Is this your first day on the job? This is a court of law, and we do not accept mistakes. Fill this plea form out correctly, or I will have you taken into custody for contempt." I did not expect a reaction like that. My client, who had clearly just taken a massive bong rip at 8 a.m. and was wearing an all-pink velvet tracksuit, looked at me like I was the biggest idiot in the world. I corrected the plea form, but the judge made me wait until the very end of the calendar to take my plea. Afterward, he called me up to the bench. In private, he said, "Sorry to ream you like that. Everyone messes the plea form up, so I always pick the youngest lawyer to yell at. The older guys will grumble and complain, but if you noticed, they all fixed their own forms, and we didn't have any more problems. Keeps the calendar running smoothly. Where did you go to law school?" After that, he invited me into his office for coffee and gave me some really good life and work advice. Turns out, he likes talking to new lawyers. Story 14. UK, bear with me on this one. I was in court listening to the most boring old defense lawyer you've ever seen. He was questioning the arresting officer in the case, which was about drugs or something like that. Anyway, he was droning on about every little detail, and the magistrate was constantly telling him to hurry along. The arresting officer was getting noticeably annoyed, and the room became pretty empty as everyone else lost interest. It was clear that everyone was bored and irritated. He kept rambling about details that no one seemed to care about or even listen to. He went over arrest times, the time the suspect was admitted, and when he was released. He had bored the officer to the point where he was barely paying attention. So he was admitted in at 21:45 on the night in question?
Yes.
And released the night after?
Yes.
And that was what? Just after 10 p.m.?
Yes.
What time after 10? I don't know. 10:15 maybe. So my client was detained for more than 24 hours.
Wait.
The penny dropped. The officer had let his guard down and revealed that he kept the defendant for more than 24 hours, which is the maximum legal time for detention in the UK. The defense rested, and the magistrate threw the case out immediately. Well played, sir. Well played. Story 15. I am not a lawyer, but I work for one. Many years ago, my home county went through an abrupt and involuntary change of judge when one of the sitting judges was suspended and disbarred for misconduct. This process dragged on for months, during which our criminal docket was handled by a carousel of visiting judges from other counties. These judges couldn't care less about our community and quickly came to resent having to fill in on the bench while our judge was prosecuted, and the governor went through the slow process of appointing a replacement. It became standard for cases to get set off or delayed. Our docket swelled, and the jail emptied because very few people were being sentenced to jail. The visiting judges granted low bonds or bonds in all but the most serious felonies. Petty criminals who didn't negotiate a plea with the prosecutor just reported back to court month after month with no resolution. One afternoon, an attorney appeared for a plea agreement involving a man accused of domestic violence for boxing his child's ears. It was supposed to be a routine plea for probation and anger management. When the facts of the case were read aloud, the latest visiting judge looked up from the docket and pursed his lips. When the prosecutor announced the plea agreement and asked the court to accept it, the judge simply said, "No." He directed the defendant to have a seat. The defendant looked anxiously at his attorney as the judge outright rejected the plea agreement and sentenced him to 30 days in jail. The defendant freaked out, as did his wife, who loudly protested that she needed him at home working. The judge pointed at her from the bench and told her to shut it or she'd spend 30 days down as well. The defendant's wife collapsed into a weeping mess of bleach blonde hair and Kmart couture. The bailiff, who honestly looked surprised at being asked to do anything beyond reminding people to remove their hats, escorted the defendant downstairs to the jail. The attorneys, both prosecution and defense, looked like scolded children who weren't quite sure what had just happened. Once the defendant's shouts faded into the belly of the courthouse and the sobs of the wife slowed, the judge addressed the courtroom. "Look," he said, "I know you all have a deal, and you know I don't have to accept it. I can leave him down there for 30 days. 30 days being a more than reasonable sentence for misdemeanor assault on a toddler." The judge continued, "I just want to teach him a lesson, and I will. You see, when I was a kid, my dad boxed my ears. He did it often, and one day he did it so hard that I'm now deaf in this ear. I know you all think it's no big deal," he said, addressing the defense attorney, "and you've been getting away with sweet deals for a while now because you haven't had a judge." He leaned back in his chair and surveyed the courtroom. "But this one hit a nerve with me. And you can file whatever complaint you want later, but I'm just going to let that guy sit down there for a couple of hours and think about what he's done. Then I'll bring him back up." We were stunned. After months of watching criminals come and go in a never-ending circle of arrests, pleas, and probation, it was honestly shocking to see someone sentenced to jail at all, much less in such an abrupt fashion. Toward the end of the court day, they brought the earboxer back upstairs. The judge gave him a lecture, and the man tearfully promised never to box his child's ears again. But seeing him sent to jail like that, even just for a couple of hours, was a pretty big "oh shit" moment. Edit. Boxing someone's ears is when you slap them on the sides of the head so that your cupped palms cover their ears. It is extremely painful and can rupture an eardrum. Story 16. This was told to me by a legendary trial lawyer in my area. I probably have some of the details wrong, but here's the gist. It was a personal injury case against the manufacturer of an industrial fan. The fan was supposed to be child-safe, but a kid got their fingers chopped off. The manufacturer claimed that the plaintiff was only injured because the fan had been modified from its original condition. The defense lawyers brought in an exemplar fan straight from the manufacturer. They also had an expert witness explain how it would be impossible for anyone to hurt themselves using the unmodified fan. The defense's case relied heavily on this theory. The guard mechanism, the expert testified, would have prevented fingers from getting anywhere near the blades. The expert was well qualified, and gave very compelling testimony on direct examination. Unbeknownst to the defense lawyers or the judge, the plaintiff's lawyer had brought a very long extension cord and plugged in the perfectly safe fan. On cross-examination, he went over the expert's theories and had him state unequivocally that it was impossible for anyone to injure their fingers on the unmodified fan. Then, the plaintiff's lawyer walked across the courtroom, turned on the fan at full speed, and began walking it toward the expert. It was loud, so he had to half-shout over the noise. He definitely had the jury's full attention. When he got right up to the witness, he yelled, "Show us. Stick your fingers in." The expert replied, "No. Come on. Stick your fingers in." "I don't want to do that." The other side leaped up to object, but the plaintiff's lawyer was just inches away from the expert, yelling at him to stick his fingers in. The expert, looking terrified, visibly shrank away from the fan. The jury came back in favor of the plaintiff. It's my favorite example of show, don't tell. If you enjoyed the video, don't forget to leave a like and subscribe, activate the notification bell, and share a similar story or anything you'd like to say in the comments. See you next time.